So you have experience working with Indian counsel and lawyers and law firms. Do you see any key differences between the barristers and counsel here and the law firms in the UK?
In terms of compared to Indian clients, so I think the Indian bar and the solicitors profession, I guess the working practices have struck me as very, very different. So if you start with the bar, the Indian bar is much more, the upper end of the Indian bar is very, very court-based and less engagement with the case throughout its life. Whereas the expectation now at the English bar is that they like to bring in the leading counsel at a fairly early stage in the proceeding, and even they will sign pleadings and be involved right from the outset of a case. And the upper end of the Indian bar seems to be much more focused on advocacy as opposed to strategic development of the case and living with the case throughout its life. That's the main difference I've spotted, but I think that seems to be changing. So the younger generation of Indian silks, possibly many of them have had more exposure to international work, particularly in the arbitration fora, and that seems to be changing quite a bit. So some of our Indian door tenants are much more used to working in what I would describe as a more of the English tradition of QCs and KCs being involved from the ground up in the development of the case. In terms of the solicitor's profession, I haven't noticed much difference. I mean, the bigger Indian law firms I've been working with seem to be very similar to their English counterparts. Very professional, very client-focused, and I've been very impressed with the Indian firms I've been working with. So I'm working with Trilegal at the moment, and I've been very, very impressed with the client care, the quality of the work, and very impressed.
Do you think India has the potential to become a hub of international arbitration? And what works in our favour, India's favour, and what needs to change to make this happen?
So I think at the moment what I'm seeing more of is Indian clients choosing Singapore arbitration. It used to be more, Hong Kong seems to have declined a bit compared to Singapore. I mean, Indian court work is seen as being something which Western advocates, English advocates it'll always be very hard to get access to court work. In terms of Indian arbitration work, I think it's a pity that there's not more arbitration work actually seated in India. And I think it's actually improving all the logistics and so on of dealing with India, whereas Singapore, the infrastructure is superb. There are ready-made arbitration suites, facilities. In many ways, it's a saturated legal market. There are great opportunities there for India, but I think it needs to become a bit more user-friendly in terms of developing facilities for arbitration and so on. And it's a great market, completely untapped, but largely untapped. But I think that's should become more like Singapore, really, I think would be the answer. I don't see any reason why in 10, 20 years' time India shouldn't be as popular an arbitration venue as Singapore and other places like London.
Can you tell us about Fountain Court's journey in Asia, setting up of office in Singapore, and I believe you're going to be celebrating 10 years this year. So how has that been?
It's been very successful. We, as you say, we set up about 10 years ago under my predecessor as head of chambers, Stephen Moriarty, and we've devoted quite a lot of time. Stephen, in particular, has devoted quite a lot of time and energy to developing it. So some chambers they have an office manager and a pot plant in their office, whereas we've got a dedicated office, dedicated representative of chambers who's there full time, and also a barrister who is there full time in India, in Singapore. and that's made a big difference. And so really only Fountain Court and Essex Court Chambers have any significant presence in Singapore. So that has developed, and I think it's given us access to much more Indian work and regional work. So I've done arbitrations involving the Philippines, Malaysia, Indonesia. They tend to be Singapore seated, and the current arbitration I'm doing out with Indian clients is seated in Singapore as well. So it's been a great hub, and it's been, in terms of its success, you can't measure it just in terms of Singapore originating work. You need to look at the whole region, which having a base in Singapore has attracted. So yeah, it's gone very well, but it's involved a lot of time and energy and effort to make it work, which it doesn't happen automatically.
And where do you see Fountain Court going next?
It would be very nice to have a base in India at some point. So we've got 3 really distinguished Indian door tenants, and we like to think we've covered 3 corners of India, having a door tenant in Mumbai, Delhi and Chennai, all very, very distinguished practitioners. So it would be really nice to have an office in India one day. That would be my ambition if we can achieve it. But barristers' chambers don't have the same resources as large solicitors' firms, so it'll be quite an investment for us. But that'd be something I would really like to see happen. But I'm not head of chambers anymore, so it wouldn't be my decision. But that'll be a nice thing if we can achieve it one day.
What do you think? Do you think the market will open up now? It's always been now it'll open up, now it'll open up. But
It doesn't feel like, although there was an indication it was opening up and so on. I felt it was a bit illusory, the opening up.
the rules that came out.
Yeah, they were very difficult to comply with, and they were quite restrictive. So I think it will one day, but I think it will be a very slow burn. I'll probably have retired by the time it's fully opened up.
I'm hoping that it should happen soon now. Yeah.
Well, we live in hope. I think it would be very good for the Indian market and very good for English lawyers, Singapore lawyers. I think the cross-fertilisation has been very healthy, we've found, in having an exchange of experience between places like Hong Kong, Singapore, London, even New York, in the arbitral world. I think that's been a healthy development.
So while we were talking about Singapore, India and London is considered a commercial hub with all big international law firms having offices here, and like a global commercial hub. Over the years, Singapore and Dubai have come up also as big commercial hubs. Do you think London still has an edge over these jurisdictions?
I think in the arbitration world, Singapore, because of its location, has a gravitational pull for some work from Asia. But at the moment, London is a growth market for legal work, so we haven't seen a decline in work. I think it's been a sort of win-win situation in the sense that Singapore has certainly grown as a centre. But the feeling is that the Singapore International Commercial Court hasn't really taken off yet. That may make a difference if it establishes roots. But at the moment, London has been a growth market. So I think Singapore arbitration has also been a growth market, but it doesn't seem to have been at the expense of London so far, as our experience. No.
And English barristers are now increasingly doing more and more India work, like bigger chunks of India work. Has this opened up a market for Indian lawyers looking at positions in the English bar? And in what way the bar could improve in accommodating Indian lawyers within its ranks?
So we have seen some Indian lawyers qualify for the English bar, normally after a period of study in England. It's very early days yet, but there are a few Indian dual qualified lawyers at the London bar. I think that will be a growth area, and I imagine that it'll be very attractive to barristers' chambers to have Indian qualified lawyers. So, for example, I'm doing an arbitration at the moment in Singapore, which involves a contract governed by Indian law. So to have junior counsel available who are Indian law qualified would be a huge advantage. I think the more Indian work we see in London, the more attractive it will be to barristers' chambers to recruit probably dual qualified lawyers. That would be, I think, a real commercial driver in the future. But it's early days yet, I think.
You've done so many arbitrations, and I'm sure you've had the experience of having Indian arbitrators.
Yeah.
How has the experience been, good or bad?
Good, I think, overall. I mean, the arbitrators I've come across have tended to be very high-powered, so retired Supreme Court judges, say. Very high-powered, very good lawyers, commercially minded, and I've been very impressed with the Indian arbitrators that I've had. Those have mainly been in Singapore-seated arbitrations. So they tend to be appointed by Indian parties, I think because they have more confidence, they know the arbitrator and so on, but and quite often there'll be, say, a wingman in a three-man panel with, say, an English Court of Appeal or Supreme Court former judge on the other panel. And the panels come across as very, very high-powered, and I think the English retired judges and the Indian retired judges actually enjoy the experience of working together. Yeah. So I think cross-fertilisation between different jurisdictions is really healthy, and you can see that not just with lawyers but also with arbitrators. So I think it's been a very welcome development, I think.
And in India, like senior advocates that we call them, they have their own chambers, and there's no concept like sets in the UK. So do you think this chamber model followed by independent bar in England works for the Indian legal market? I
think it could do, and I think that probably be a way it develops in the future. At the moment it's very small, and so leading Indian silks will have a few people they work with, but nothing like, I mean, our set now has 100+ members.
Yeah.
And I think the more cross-fertilisation we have, so our Indian law tenants come here, they see the Chambers model working, and I think they come away thinking it's a really good model.
Yeah.
But it will require, I think, more people to see it as a model, and for the Indian bar to become a bit less individualistic and a bit more collegiate.
Yeah.
And they'll see the advantages of cooperating, particularly with large-scale litigation. It's really useful having... So I've just done a case where it involved different fora in New York, London, Chile, and it was really useful being able to build a team of barristers, and the solicitors firm liked it too, all from within the same chambers. So there was me as the senior silk on the team, then I had a junior silk from Fountain Court, and then a junior barrister from Fountain Court, and that really advantageous, and we could communicate really quickly and readily. So I think the chambers model, our type of chambers model, would translate really well to India, but it can't happen overnight. Because at the moment it seems to be geared around big personalities attracting a few close people that they'll work with, but nothing like our model. But I think it would translate very well to India, in due course.
The Arbitration Act in England is at a cusp of some key reforms. What are some of the lessons from these reform process that emerging jurisdiction can learn?
I guess that in terms of the management of the process of appeals from arbitral awards which are manifestly wrong, I think that that regime is still too narrow. I think there should be more court access, because the quality of arbitral awards really varies depending on the quality of the arbitral panel that you have, and I think the right of challenging arbitral awards is a little bit too limited. I totally get the advantages of finality to arbitrations and so on, and not having an elongated appeal process and so on. But I think the right to appeal from manifestly incorrect decisions is still too narrow. So I don't think we've reached a point which I would recommend rolling out to other jurisdictions at the moment. So yeah, I'm a bit wary of suggesting that our arbitral legislation and the quite modest reforms that have been made to it are a model that can be rolled out easily at the moment. There's quite a long way to go.
Okay. And India has recently seen some judgments that appear to legitimize litigation funding. Based on your experience with Pakar litigation, should jurisdictions treat this kind of emerging jurisprudence with caution?
Personally, I think so. So Singapore has, we were involved in talking to, because Alex Taylor, our senior clerk, is quite well plugged into Singapore, and various English barristers and the English legal fraternity were consulted by Singapore, who are rolling out litigation funding. I think in England, it's basically approved by the judiciary and the state, and after we won in the Supreme Court in the Pakar legislation, the government rushed through this emergency legislation to reverse the outcome of Pakar, but it was swallowed up by the election, so that bill is dead at the moment. And it remains to be seen whether the incoming government renews it or not. I think the problem is everyone assumes litigation funding is a good thing, full stop. I'm not convinced it always is. I think sometimes the model of litigation funding could do with some more regulation to avoid bad practices. So the example that's given is, the post office scandal with sub-postmasters being prosecuted by the post office. And everyone says that they wouldn't have been able to bring their case against the post office without litigation funding, which is true.
Yeah.
But the funders, the actual sub-post office masters were left with about 20% of the damages after the funders had taken their cut. So I think there should be more regulation around funding. And the advantage of the Supreme Court judgment was it operated to restrict the amount that funders could recover effectively. They were limited to multiple of the outlay that they had made into the litigation. And I think some of the damages-based funding, which takes the cut of the damages, can leave the claimants with very little money. So I think I would be really cautious about just adopting the current English model of litigation funding. I think it needs to be regulated, particularly having caps on the amount that funders can recover. We were met with a wall of hostility when we brought that case, because litigation funding has become quite embedded here and it's generated a lot of litigation, but I don't think it's always been to the advantage of claimants. It's great if you can fund a case which would never otherwise be brought before the courts, but I think the cut that funders can take sometimes is far too big. So I think it's the main lesson to be learned from our model of litigation funding.
Okay. And any important career highlights that have left you with important lessons in life as a barrister? So I guess it's a quite hard job. It requires quite a lot of stamina. I remember, and you have to find interest, something interesting in every new case. And one of the first cases I did at the bar, I came in as a junior barrister for the Bank of England in a very famous piece of litigation called Three Rivers, where the liquidators of BCCI sued the Bank of England. And I came in as the baby junior. It lasted for a long time. By the time it went to trial, I was a QC. But the first leader on the case was Sam Stamler, who's a very well-known, very famous English QC. Very senior. He was like in his 70s when I was first instructed, and he was a really lovely man. He invited me over to his chambers for a cup of tea when I was first instructed, even though I'd been at the bar for about a year, and he was genuinely interested in hearing my views about the case because I was new to it. He wanted to know what perspective I had of the case and so on.
And while I was sitting with him, his senior clerk brought in a new set of papers for him. As we used to have our papers, used to have pink tape around them, all new sets of instructions. And he cut open the tape while I was in the room and said, "You know what, I still feel a thrill when I get a new set of papers and I cut the pink tape." And it always just stuck with me, that enthusiasm for his work. So I think, and he'd been going for years and was still enthusiastic about a new set of papers. So I think this kind of curiosity is quite important. Stamina is really important because it can be really, really hard work at times. And obviously all the normal attributes of advocacy skills and intellect and so on are all quite important. But curiosity and stamina are what keep people going, I think, and makes the difference between having a successful career and becoming quite jaded quite quickly.
That's interesting. And who has been your mentor?
So I think my first pupil master actually was a barrister called Trevor Phillipson, who very sadly died in his early 50s when he was at the prime of his career. He was relatively junior QC and became very suddenly ill and died. And I've always kind of modelled my advocacy style on him. He was very, very, very smooth talking, very relaxed and calm, not aggressive at all in court, but very firm, never discourteous, was a very, very good cross-examiner. It was like picking people's pockets. They would think that they're having a nice chat with him and he'd got all the answers he wanted without them realising. Great charm and sophistication, but underneath the surface, he was like a graceful swan on top of the water, but underneath the water he was paddling furiously because every time he went to court there was absolutely ferocious preparation. He was so well prepared, he knew the case backwards, and I thought that's a good model to follow if you want to be successful. So yeah, he's been my mentor. Trevor Phillipson was very, very a very sad loss to the bar, but he left me with a big legacy.
That's great. And quick 2-3 things that you would advise to the young members of the bar.
So I think don't take it too seriously, because sometimes it feels like it's a life or death thing, winning or losing. And I think you discover after a while that you can't win every case, because not every case is winnable. And I know a lot of junior barristers I work with get really, really upset, and it knocks them for weeks if they lose a case. Particularly if you expect to win a case and you don't win it, that can be very upsetting. You have to move on from losses quite quickly, and just move on to the next case rather than dwelling on things. I think look for whatever is interesting in the case. It can be a very dry commercial case, but every case has some interesting angle to it. Even if the law isn't particularly interesting, you don't think the facts are very interesting, there's always something, even if it's the personality of the witnesses or the clients, or you get on with the solicitors who are instructing you, there's always something positive to take out of a case. I find people get too put off too quickly by the superficials of a case, thinking, oh, this looks very dry or boring, and there's always something interesting to find in any case. And what I said earlier about stamina and needing to pace yourself, I think some people burn out very quickly at the bar. And you need to make sure you get proper time off and devote proper time to family and eventually for the younger barristers' children, and don't regard work as the be all and end all of everything. So I've spent a lot of time and money on proper holidays.
Thank you so much.
A pleasure.